Welcome to the training module on Enduring Power of Attorney. An enduring power of attorney is best defined as a legally binding document that empowers another person or persons to manage the financial affairs of the donor at a time and in a manner set out in the document. The donor is the person giving the power of attorney, while a donee, also known as the attorney, is the person receiving that power. Be aware that it is common for there to be more than one donor, often a husband and wife, and more than one donee or attorney, often their children. Throughout this module, the singular of donor and donee also covers the plural, donors and donees. There are differences between a power of attorney and an enduring power of attorney. The main differences are: a power of attorney does not require a JP to witness. Any adult may witness a power of attorney. A power of attorney ceases to have effect once a donor loses legal capacity. An enduring power of attorney requires a JP or similar to witness. An enduring power of attorney comes into effect when defined events occurs, such as a donor losing legal capacity. Enduring power of attorneys belong to a group of documents collectively referred to as advance directives. Whilst the documents in this group serve a similar purpose, to record the wishes of the donors about what they want to happen at a time when they are no longer able to make decisions for themselves, they differ in terms of the areas which they cover. Thus, an enduring power of attorney deals only with finance, property and related legal matters, whilst an advance care directive deals with lifestyle and medical treatment decisions as well as end-of-life and palliative care decisions. Please note that the witnessing of an advance care directive is dealt with in a separate learning package. Every adult should have an enduring power of attorney as well as an advance care directive. Who knows when you may be injured, fall ill, or suffer a catastrophic medical event? In such situations, how will your financial and medical affairs be managed? Advise the donor that an enduring power of attorney is not valid until the attorneys or donees named in the document have signed the form of acceptance, which is part of the document. The enduring power of attorney comes into effect when the conditions specified in the document are met. Before you proceed to witness an enduring power of attorney, you need to satisfy yourself in regard to the following 4 matters. Satisfy yourself that the donor is over 18 years old. Until a person reaches the legal age of 18, it is the parents or guardians who have power over the person's financial and legal affairs. Satisfy yourself that the person before you is the person named as the donor, that is, the person who will be giving the power to another party and who will be signing off on the conditions. Please note that it is not permissible for someone to sign off on an enduring power of attorney on someone else's behalf. Satisfy yourself that the donor understands the content and practical effect of an enduring power of attorney. Nobody should sign off on a document unless they are aware of what powers they are handing over to their donees. The best way for you to satisfy yourself is to ask the client to tell you, in their own words, what the purpose of the EPA is and to explain the nature and powers they are handing over. Satisfy yourself that the donor is participating freely and voluntarily. If there is any hint that the person is being coerced, you may need to take certain steps in regard to any persons accompanying the donor. For example, asking them to allow the donor to speak for themselves, or if necessary, ask the accompanied persons to leave the room. If you are not satisfied about any of the above, then you must not witness the document. Most people you see to have an EPA witnessed will be obviously over 18 years old, and you will not need to ask them this question. If, however, the person looks borderline, it is best to check their birth date when you ask for formal ID. You are required to verify that the person making the enduring power of attorney is the person identified in the enduring power of attorney. Therefore, check their names, address and date of birth in the identity documents they provide to you matches what is specified in the enduring power of attorney. This may require multiple ID documents to get this information. For example, a passport on its own does not provide an address. Neither does a Medicare card. A combination of a passport and several utility bills in the donor's name will provide the information required. Of course, a driver's licence has all the information, but not everybody has one. Satisfying yourself in regard to age, identity, understands the content and effect, and signs freely are the most important thing you do when witnessing an enduring power of attorney. If you are not able to satisfy yourself in regard to one or more of these matters, then you must decline to witness the document and give the reason for doing so. If your concern hinges on the ability of the donor to understand the content and effect of the document, it may well be that they no longer have the legal capacity to do so. In that case, you should inform the donor and the persons who brought them that the document is not able to be witnessed. You should further suggest that the donor seek legal advice or contact the South Australian Civil and Administrative Tribunal or the Office of the Public Advocate. It is now time to work through the document from the beginning and culminating with both parties, that is the donor and you, the JP, signing off. Step 1. It is now time to deal with any limitations to the authority given by the donor. Here, the Enduring Power of Attorney form provides the donor with blank pages on which to note any restrictions to the authority given to the attorneys. For example, the attorney may be given the power to operate a bank account, but not be able to sell specified assets such as the family home. It also provides the donor with the opportunity to give clear directives. For example, that decisions made about goods and chattels should be in accord with the wishes set out in the donor's final will and testament. Step 2. If the donor has named only one attorney, then you need to put a single line through the words jointly/jointly and severally. If more than one attorney is to be appointed, then it will be necessary to stipulate how they operate when making decisions on behalf of the donor. This requires a donor to choose between two options, namely, number 1, to have all the attorneys work together when making a decision, that is jointly, or number 2, to allow them to work together or individually, that is jointly and severally. Once the donor is clear about this matter, delete the inapplicable words, that is jointly or jointly and severally. As with all documents, we witness the deletions must be initialed by both parties and dated. Step 3. Requires the donor to indicate the time at which the enduring power of attorney is to come into effect. Again, the enduring power of attorney form requires the donor to choose between two options. Number 1, upon the execution of this deed and remain effective, notwithstanding that I may suffer any subsequent legal incapacity. In short, immediately the document has been executed or witnessed. Number 2, only in the event of my suffering any subsequent legal incapacity. Having made the choice, delete the inapplicable words, initial and date. Once the donor has recorded any restrictions and directions, the blank space should be Z'd out and initialed in the usual manner. Step 4. When all the above has been taken care of, it is time to execute the document. This involves a donor signing in the space allocated and having it countersigned by you as an authorised witness. Not deleting the inapplicable wording on the enduring power of attorney may result in the enduring power of attorney not being accepted by a third party. It is critical that the JP pays specific attention to this matter, as the enduring power of attorney may sit in a drawer for years and only be produced after the donor has lost legal capacity. It is too late then to find out that the document is not valid. The enduring power of attorney presented to you may look like the document shown here. This is from the online Enduring Power of Attorney kit. Enduring powers of attorneys may be produced by the donor's solicitor or from another Enduring Power of Attorney kit produced commercially. Although the format might vary, the same information is presented. A high-resolution version of the document on this slide is available for you to download from this training site. There are 7 conditions listed when a JP should decline to witness an enduring power of attorney. These are: when the JP is not satisfied the donor understands the nature and effect of the document; when the donor does not appear to have sufficient English to understand the nature and effect of the document, and a suitable interpreter is not available. When the donor brings along a friend or relative who is to act as an interpreter but is also a donee cannot act as an interpreter for the donor. When the document is not written in English, legal documents to be used in Australia must be written in English. When the donor is only able to communicate through their carer who is named as their attorney or donee. When the JP is not satisfied that the donor is signing of their own free will. When the donor brings the JP an existing directive and they want to alter the document. In this case, the EPA must be revoked. Once witnessed, the EPA is not able to be altered. However, the donor can, while still possessing legal capacity, formally withdraw or revoke the enduring power of attorney. Once revoked, using the revocation form provided in the Do-It-Yourself kit, the donor will be able to make out a new enduring power of attorney. This concludes the session on enduring powers of attorney.